As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
No! Don't break my window! Don't break my window! Do not break my automobile! Oh, damn it! Damn it!
Good morning, everyone.
Good morning.
All right. Are you ready on the motion for Michael? Is it McCreary?
Yep.
All right. The clerk can call the case.
2356485, the people of the state of Michigan versus Cornell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth defense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay. Appearances.
Edwin Sawaki, P54A28, appearing on behalf of the people.
Good morning, Your Honor. Truth Science appearing on behalf of YouTube.
Cornell Michael McCreary, natural person, not a corporation, natural flesh and blood.
Okay. Thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Abri pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
Now, of course, all of my normal subscribers who watched the previous video already knew that this motion was going to be denied because it was frivolous. But, you know, the courts have to play by the rules and do everything the right way. So this man's motion was denied, as it should be.
And Attorney Washington, I know you want to put your appearance.
Oh yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turning over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a multiple judge court. This is a multiple judge court. Chief Judge Conoco just addressed it. You received your motion in writing, and he responded on the record, and he denied it. There could be no more discussion from me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
it's already been addressed in your pleadings, and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying per the rule, due process.
You're still talking about something that has nothing to do with.
Well, I object, and it's on the record.
Yes, and I've noted that.
Well, since we're objecting to things, I object as well, Your Honor. Get this man out of your court.
So as far as the exam, The time is now 10:17. Are you ready to move forward with your presentation?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me speak, Judge. Like,
I
you
am
give
letting
him
you
a fair
speak
chance
in regards to what I'm
to
asking.
respond, but you won't give me a fair chance to say or speak.
Mr. McCreary, I let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call witnesses.
Based on what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were a Chief Judge Pro Tem. And per the motion, it says that if you were the Chief Judge Pro Tem, it's supposed to go to the State Court Administrator. This gentleman here, I'm not familiar. Like, first,
you're still addressing the motion to disqualify.
My due process is being violated,
and it's not.
I mean, you won't let me tell you
why. It seems as if you can read it right. The court rules are very clear about motion to disqualify. There's no black, it's black and white. So Mr. McCreary has been denied.
Okay, we understand.
And if you knew that, it also says that there's the timing in which the court can address that can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is I have a right under 6.110 to call witnesses.
Yes, you do.
Things of that nature.
And why aren't you prepared today?
Because you won't let me speak.
I didn't know. I said, why aren't you prepared today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the Chief Judge.
No,
that is the
process. It's not.
That's why I'm not.
I can't deny a motion to disqualify in a multiple judge court.
Can I pull up the rules?
Read the court rules. 2.003.
I'm familiar with it very well.
We're not that familiar.
Crampton versus Michigan Department of State.
You can state any case law you want in a multiple judge court. I cannot handle your motion that you filed. It goes to the Chief Judge. Chief Judge, I am Chief Judge Pro Tem. Two different things. I cannot handle my own motion to disqualify. That would be biased, Mr. McCreary. So do you have witnesses to be there?
You won't let me respond.
Yes or no?
No, I don't.
Okay.
Because my intentions, as I stated, under this
It's just
rule.
a yes or no. I just want to know. So you can finish looking under court rule 2.
Why am I not being allowed to address the court and give it a fair exchange? Like
I'm asking you questions. This is not your courtroom. I'm asking you.
I'm not trying to disrespect.
I have given you all the leeway up until this point.
I mean, the law.
Today's the exam day. Go ahead and check your court rules. Get back to me.
Now, what's happening here is Mr. McCreary is having a hard time understanding that his motion was denied, and he's pretty much throwing a temper tantrum. He really thought in his mind that all of that gibberish that he spouted last court appearance, he thought that was actually going to work, and he did not prepare himself for the situation that is at hand right now. He didn't think that his motion was going to be denied, so he has no defense. He honestly thought that he was going to win that motion and have the judge removed. It's just mind-blowing. This man is out of his league. He needs to use the legal aid that is on standby, because if not, he is going to be in a leap of trouble.
Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object. I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the higher court.
You want to research 2.003 first, because that seems to be what you were stuck on. I want you to go ahead and find that.
And there's Michigan case laws.
Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
Okay, section B, who may raise? The party may raise the issue of a judge's disqualification by motion, or the judge may raise it. B, disqualification of judge is warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, the judge based on an objective and
those are the grounds. You got to get to procedure. Section B. 3. A, start there. I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down here.
In a court having 2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion de novo. That's right. The written order that will be provided to you stating the time. So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have evidence. I mean, since you're forcing compelling, which violates my rights under UCC 1-3. Wait, also, I'd like to make it non-pro ton. Again, motion to challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was the 30th, I believe it was. The prosecutor gave me 15 pages, and he had tested on the record. This is 15 pages all they have. There's no warning. There's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations.
It is so satisfying to witness this judge not playing around with this fool. He's making 0 sense, and she's having none of it.
So I'm ready to move forward. And if you want to call witnesses, if we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So, Attorney Washington, is there anything you'd like to put on the record before we begin?
No, Your Honor.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People will have to address the court first.
Yes, Your Honor. People have Exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCreary, pled no contendere, assault with intent to maim, related as People's Exhibit 1.
Oh, you say I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that.
Under what court? Under what statute?
Oh, I'm sorry, Your Honor.
I object. I wasn't convicted.
MCL 766 11B 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dalton Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCreary, you review the document first?
Yeah. Okay, well, what does this got to do with the case? Robbery not armed, and assault with intent to maim. I have the transcripts at home and the court order from Judge. He was a visiting Judge Dalton Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was. He said that the officer in this case lost his entire file.
Can I see the
and I have this transcript at home. How you gonna speak on someone you lost the file? This case was the felonies were lost. It was a misdemeanor. Aggravated assault, and that's the case that, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can, because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
Assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? The jury trial was held in front of Judge Roberson. You were sentenced and committed to Wayne County Jail. Your sentencing on September 8, 2000. So for exam purposes under MCL 766.11B1B, exam purposes only. This satisfies with the, you can place your objection on the record.
Well, I would like to say, because in this case, I have the transcripts at home. And I object because this man just lied to the court, because in this case, Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. Then he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this, and I would ask that you hold him in contempt of court for committing perjury.
I'm going to hold you in contempt of court in a minute. So I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCreary was convicted of intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester, because my intention is to call the chief detective on the stand, because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So if there's a potential witnesses on this case, now's your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purposes of impeachment under People versus Stanaway. I also would like to address to the court, Kim Worthy, I believe it was last year, put a witness list out for officers who have previously testified falsely in court proceedings, that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery, as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges, and the prosecutor is not doing anything. Also,
can I address that first? Yeah. So, Mr. McCreary, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then. Well, but you can do that on purpose.
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom and was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the line all these years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying today?
No, my brother Charles had 5.
So you have to address your brother today when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdrawn because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the Wrongful Convictions Unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And, you know, for this gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript. to be able to move forward to the next steps that you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the recusal aspect.
No, I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everyone else does. Ready to call your first witness?
Yes, I am, Your Honor.
Mr. McCreary, do you want to sit at the table up here?
I would ask that the police officer be called first, because we have to establish how he investigated and other things of that nature.
Now that would be you working for the prosecutor's office. You don't get to tell them how to try their case.
No, I'm not saying that. What I'm saying is I want to question that investigation.
Okay. And if the prosecutor, are you going to address their request or call who you said you're going to call?
I have one witness.
Okay. So in this case, he gets to start with
can I
however he wants
call
to.
as a witness, being that he's trying to bring my brother? I would like to
So
establish.
procedurally, prosecutor has the burden of proof. You should know that.
Well,
So they have to go first. They have the burden here.
well, they have no
And then
evidence,
you
Your
can
Honor.
call
for the-
witnesses if you like to. If
Yeah.
you feel necessary, you can do that. We'll discuss that after the legal rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just said it's in the paperwork.
I would like you to stay focused, okay? And the first thing we're gonna do is hear testimony from the people's first witness. That they have a burden. So please, call your
People call Norman McCreary.
I wonder why Mr. McCreary didn't wear his illustrious fez today in court. He stands in dishonor right now.
Remain standing, raise your hand. Raise your right hand. Once you sit down, that microphone, when you're talking, you can put that in your lap. Okay, Mr. Sawaki, whenever you are ready.
Sir, could you state your name for the record, please?
Norman Leon McCreary.
And what brings you to court today?
The incident that happened on the 9th, and I was leaving the house after another incident that happened inside of the house.
Okay.
And I went to my next door neighbors.
Okay. Let me back you up a little bit there. Was that February 9th this year?
Yes.
Yes, and did that?
Objection leading.
Piece of paper.
No, I have some. Objection, he's leading the witness, Your Honor.
I think, sorry, go ahead.
Because he said it.
One witness testified that it was night. I was merely clearing up the aspect of which the 9th of the month it was.
Objection, it's still leading.
Okay, I'm going to overrule that because they're preliminary matters as far as date and time. And we have date night, and I believe it's certification, not to be. So go ahead and get your
Was February 9th, correct, of this year?
Yeah.
Okay, and then, what address did that occur?
14739 Homer, Detroit, Michigan.
And, that's in the county.
Yes, my county.
Because all the CEOs work together.
Now, you had confrontation, right?
Yes, if that's what you want. Yes, confrontation. We talked after
Okay. Who did you have a confrontation?
Cornell McCreary sitting right there.
Could you,
Objection, Your Honor. I would like to also there was a one single photo lineup, which he seen my picture prior to this exam. It was a photo lineup single. And this is how, you know what I mean, he's my brother, true. There's a procedure on the due process. Oh, okay. Yes, I would like. I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at this discovery, it says that a single photo was shown to Mr. McCreary. And this violates what is it, United States versus Wade, I believe it is.
It would be Wade to address that. However, Mr. McCreary, that's why it's very delicate for you to represent yourself. You just stated that he's your brother.
I mean, but it's still a procedure, Your Honor. That has to be followed.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can identify you from that day.
But it's still a suggestion. It violates the law.
We're not even getting to the line at this point.
Well, I'll place my objection.
I hear you. So, Mr. Walker, can you continue with your questioning?
Could you describe a piece of clothing that the gentleman?
He has a blue jean jacket that I had.
You know, let the record reflect that witness has identified the defendant.
It's not reflected.
What at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, I prior to seeing my brother Cornell, I had went into the house the day before on the 8th, and the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room, and the second door was kicked in and damaged.
Objection, Your Honor. He just committed perjury. The first door is not kicked in and speaks of.
Sir.
Oh, okay. I'm sorry. I didn't know I had to say it. I'm sorry.
What you're doing is you're testifying as to what happened. All you can do in this case, if you're saying that he's not telling the truth, is on cross-examination, you have the opportunity to question him and possibly raise issues of credibility. But at this time, you're testifying as to what happened and not objection regarding the rule of evidence. Okay? And every objection has been placed.
I understand this, man.
Now, if you would just let your lawyer help you out, you wouldn't be making these silly mistakes.
If I may finish, upon going into the kitchen.
Second. Describe this house. Is there like an apartment?
It's an income bungalow. So it's an upstairs and a downstairs, and they're separate, and they both have separate utilities. And the downstairs is the part of the domicile that, you know, I was having. You know, I became the executor of the estate. So, you know, I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs.
Cornell
McCreary. So when I came downstairs.
Just so the record's clear, whose estate are you talking about?
My deceased mother's estate, named McCreary.
Who lived up? Did someone live up in the?
Cornell McCreary stayed upstairs after he was released from prison.
Okay. So you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
so
I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were, you know, incurred in, you know, the house.
What, after you took the pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, you know, she grew up, you know, we grew up with her. She's like a mother. Okay. So I went next door and, you know, visited her. And then upon leaving, when I was coming out, my brother was coming. Cornell McCreary.
Okay, you were coming out of the neighbor's house. Where was your brother coming out?
He was coming out of 1417 home.
Okay, and that's where he lives. Correct.
He lives in the income bungalow upstairs.
Okay. What happened when you got it?
He confronted me, and you know, I told him, I said, "So is this how you're gonna do our mother's house?" And he was, you know, he started talking about taxes, which he hasn't paid. You know, so and then I was like, you know, and I tried to ignore him. So he's like, "Yeah, so you going to go to the police on me and all this kind of stuff." So, and you know, I was like, "Yeah, I'm going to the police." And then he's like, "Well, somebody's gonna die today, me, you, or the police."
Okay.
So, and then I ignored him, and I went to my automobile.
Okay.
And I was about to get into our automobile. He picked up.
When you got into your automobile, what happened next?
He picked the brick up and hit the car with the brick.
Okay.
So I jumped out of the automobile and, you know, ran after him, and he ran. So, you know, I was like, man.
Okay. Where did he run?
He ran up on the porch of 1417 down.
Okay. You sit tight, Your Honor. When he ran up, when he's on the porch, what did you do?
I went, you know, I ignored him and went back to the car because I was going to go out of police.
Okay. And when you went back to your car, what happened next?
He picked the brick up again and hit the car again. So now this time I ran after him again, and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon. Okay. And fired into the air twice.
Okay. Fired it twice.
Yes.
And then what did he do?
And then he.
I'm sorry. Did you say into the air?
Yes, into the air twice. And then he looked at me in the eyes and then pointed the weapon at me and shot in my direction.
Damn. This is absolute madness. This Moorish brother pulled a gun out on his own brother and shot in his direction. My question is, how is Moorish science helping this brother if this is the things that he is doing to his own siblings? What is the point of gaining quote-unquote knowledge of self through the Moorish fundamentals if these are the things, if these are the acts that you are still committing against your own flesh and blood? How is Moorish science helping this man's life? That is my question.
And, you know,
when he shot in your direction, where did the bullet go? You know?
It's a field right across the street from the house, so I can't say where it went, but it went in that direction towards the field.
Well, what did that do you as far as?
I was. First of all, I was upset that my brother would do something of that nature. Then, you know, I kind of feared for my life, so I jumped into the vehicle and drove off.
And you said the weapon was what type of weapon again?
It looks like it was a rifle. It was a black. It could have been an AK.
But you're not sure, right?
No, I'm not sure.
Okay. And after you got in your car,
I was really upset. You know, I went directly to the precinct and I filed a report.
Okay.
And
I have nothing further for this witness at this time, Your Honor.
Ross, did I make it?
Yes, I make,
And Mr. McCreary, and just want to let you know, you are bound by the rules of evidence. If the prosecutor objects, if you need any help with it, Mr. Washington is there. Okay?
how you doing there, Norman McCreary?
I'm here.
You all right today? Okay, let me direct you. You stated that I shot in the air. Is that correct?
That's correct.
Okay, isn't it also correct that you said I shot in the ground as well?
I didn't see you shooting at the ground.
Well, no, I'm just saying, is it just a no? Did you say I shot in the ground?
I didn't see you say at the ground. So
Okay. Your
it's
Honor,
not a yes or no.
I would like to reflect for the record that at another proceeding, the prosecutor stated that he said that I shot the Brown, shot the Aaron Smoke, shot him 3 stories. Okay.
Your Honor, I don't recall that, and today we have to go by testimony of the witness. That's what we're here.
Well, you were the spokesman for it. You're representing him. Okay, that's all right. Okay, you spoke about a probate issue. Am I correct that you were the executor, sir?
Yes, I did.
Okay, isn't it true? Have you ever committed perjury in court? Have you ever committed forgery or anything that nature? Oh, Your Honor, you just lied. Here's the paperwork. This impeachment with. Isn't it true that you forged my name?
What does this have to do with?
Well, it's impeachment, sir. It's impeachment, sir. People versus Standard laws, the rules of evidence. Isn't it true that you forged my name, David McCreary? Paul McCreary, James McCreary, and Charles McCreary?
That is not true.
Okay, I have affidavits from him notarized where he stated that the brothers gave him permission to sign individuals' names, and the judge issued a show cause hearing. Give me a second, please. Okay, here we go. Here's an affidavit I would like to get a copy of to the prosecutor's office. It's signed and notarized by Norman McCreary. And this is allowed for impeachment purposes. He just committed perjury on the stand, Judge. And on page 2, Norman said that the other brothers, Charles, James, and Paul McCreary, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it to your witness and see it too. You just lied on those, sir. And it's signed and notarized by him in the probate, Wayne County probate proceeding.
That was forged by the judge. It was not, and I had to follow the judge.
He committed perjury. And I have an affidavit from my brother on the phone too that he didn't give me permission as well. And I'd like to have, that's what I was saying about witness call judge.
F1.
Your Honor, this is just an affidavit. It doesn't show anything about perjury. And not only that, but
it's forgery, sir.
1 second, Mr. McCreary, one at a time.
In order, the court rule, in order to be impeached, it has to be conviction. Therefore, I'm going to object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that. That's why.
The court rule.
The Michigan rules of evidence
Judge,
allow for.
He just lied under oath, and he lied under oath in the courtroom. Just why I don't like this
Mr.
subpoena.
McCreary, let me finish addressing the objection. Under the Michigan rules of evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone. No court other than an affidavit signed by another person who's not here to testify.
This is affidavit. This is what I'm saying. It's signed and notarized, Judge. And then I was also previously, I had transferred by police officers in Wayne County from complaints about them, and the judge allowed me. I just asked him, did he ever forge anybody's names and whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCreary and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow this gentleman to come in here?
Mr. McCreary, you have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore. There's vindictive to second prosecution.
I'm not allowing you to present an affidavit. There's no conviction of the 3 things: dishonesty, falsehood.
Okay, can you show me in the rules of evidence where that is? It says about convictions. Because other courts, I remember, I can't think the chief judge from '99. He was here. He allowed.
1999.
Yes, Cambridge P. Harper was my attorney at the time. There was the deputy sheriff and Clifton needed. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felonies?
It shows that he said.
Yes or no? Does it say he committed felonies?
Yeah, right here. It says that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felonies.
Forgery is a felony.
I know it is. So
Identity
is lying,
theft
so is shooting
and
people,
perjury.
so telling people you're going to kill them, so is murder. There are a lot of crimes.
So that's discrimination on your part.
If it hasn't been proven or established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the
Charles McCreary, and I would like to admit that in evidence as well, because he's saying that he didn't forge these people's names, and my other brother's saying that he did. And this refers.
Michigan rules of evidence.
And can you give me the rule?
609.
609. Okay.
609.
Go here. You just lied under oath this time. MRE 609.
For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall not be admitted unless the evidence has been elicited from the witness or established by the public record finished during cross-examination, and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
okay.
I'm not admitting that evidence.
Can I
move on to the next question?
Can I give you speak about the rule?
I'm denying objection. You just place that you disagree and object to my sustaining the objection.
Yes, I do object, and this goes also. Again, I would like to renew my motion to recuse under People versus Crampton, Michigan Department of State, Crampton versus Michigan Department of State, Kane versus MVOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under in this court in 99.
I didn't do that.
Well, what I'm saying is I asked him a question. He said no. I have evidence to show he did.
I have evidence under
and it
evidence 609 that allowed for you to establish that. Next question, Mr. McCreary.
Okay, now here you just spoke on the rule, and I would like to argue the rule. It says unless solicited, I solicited from him and then dealt with theft and dishonest crime. And this court, I feel, is being biased toward the prosecutor.
You're sounding like a broken record. I heard you already.
All right.
Denied.
Okay. Can I continue? And I object again.
Please.
Mr. McCreary, isn't it true that you consider yourself a sovereign citizen?
Ain't that some ish? A sovereign citizen questioning another sovereign citizen and trying to discredit him because of his sovereignty, his quote-unquote sovereignty, I mean.
Does that have to do with this case?
Well, it's relevant. It's relevant. Goes for credibility impeachment.
I object to the relevancy of the question.
It goes to the credibility of the witness and to test his credibility.
So sovereign.
People versus
sovereign.
people
Mr.
versus
McCreary, the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've established
I'm
that.
being dishonest.
I said, don't say that it's about dishonesty, because you stated that you're a sovereign as well.
I mean, yeah, I agree.
So what is the relevance
I'm not
of
the straw
him being a
man.
sovereign today
I'm
while
not,
he's
I'm not the straw man. What I'm saying is,
answer the question. How is it relevant that he's a sovereign citizen?
because he's the same person that fights you guys. In court, he's issued
I'm indigenous to this land. What you should answer.
Both of you all, in a minute, in this exam, there's gonna be some contempt hearings going on. If you all don't stop. I don't care if he's a sovereign citizen or not. That has nothing to do with the case here today. So I don't find it to be relevant. So next question.
So you stated that I shot in the ear. Is that correct?
Yes.
Okay. You also stated that I shot at you as well.
Yes.
Okay. Is there any witnesses to this? And what time was this about?
Well, I can't remember this young man's name, but him and his mother was outside.
Okay. Okay. So what time was this?
I can't remember.
You can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work.
It was at work
in Oak Park.
It was around probably after 5.
You just said you didn't know, Mr. Brown.
I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5.
Okay. Are you familiar? Do you recall that I worked at Glory Supermarket in Oak Park?
I don't know. I didn't know where you barely.
Okay. Now let me ask you this: for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about I got
Objection.
Well, no, I'm trying to establish that he knows that where I worked at. This is what
I knew that you had got a job, but yes,
at the supermarket.
Yes, you did.
To the McCrearys. If there's an objection on the floor, everyone has to stop talking.
Thank you.
For a couple reasons. The court reporter, you are torturing her right now because she cannot take down anything when everyone's talking. So please, one at a time. There's an objection on either side. Stop talking. So there's an objection. What is your objection? Relevancy. What is the relevance of the 2 bottles of rosé?
To establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you worked on that day and time.
Okay, this is what I'm
it's not
trying to.
relevant as to the day and time in which you were at work.
Well, the time of the crime that he stated. I mean, how do you not know what time the crime was committed? You're saying the date, but what time?
What time about you worked, where you worked, or the time?
Well,
of the day?
what I'm
Because
trying
he
to.
said after 5. It had to be after 5 if you worked until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
Well, I worked afternoon.
Is that correct? What he just said?
Pardon?
He said after 5 because he gets done work at 4:30. Not sure what time, but somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the event?
The reason that I stated that, Judge, is because he knew where I was. I was telling him about how cheap things were there with my employee discount. So he just stated he didn't know where I worked, but he knows where I work. Because I gave him 2 articles from the job for his birthday.
Okay.
And then I have witnesses that I would like to call in: Robert Van Dyner, Gerald Flowers, and other people. Yes, because Mr. McCreary was paid money. This is why
Mr. McCreary.
Okay.
All
right.
So
Mr. McCreary, isn't it true that you allowed Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some point?
I'm going to object to relevancy.
Well, I'm trying to establish that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of impeachment.
No, for impeachment, I read the rule 609. Unless you have some other route, you asking questions about.
Well, the thing is, he's stealing money. If you look at the text, like the text is still in my mind.
And guess what?
After
Even
10 years,
if
20
he
years,
was stealing money, it wouldn't be relevant today during this testimony.
This man just does not get it, which is why he needs a lawyer to represent him. He is sitting up here asking all of these irrelevant questions. So, did you have Big Mac sauce on your burger? Sir, you're in court for shooting at your brother. Whether or not he had Big Mac sauce on his Big Mac is irrelevant. This man is just asking all of these ridiculous questions that have absolutely nothing to do with this case. How is your line of questioning supposed to help you win your case for shooting at your own flesh and blood, you Moorish sovereign citizen?
So he can steal from me, and that's okay. And other people, it's okay.
No, it's not okay.
And I've made reports, and the 10th precinct is retaliated because I made reports against their officials down there for failure to protect.
You are muddying the waters, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain an objection. It's not relevant. Question.
Okay, isn't it true, Norman McCreary, that the taxes Mamie McCreary are still in her name after 20 years of being deceased, sir?
Yeah.
No, this your witnesses committed felonies and you're committing felonies with them. You and Kim work.
Okay.
And there is documented. I'm just this purpose of
it's
it.
Just this, well,
for purpose of it.
Okay. All right. Next question.
May I ask you a question? How did you come to work here to correspondence? How did you get here? Did you drive or were you brought?
Objection, Your Honor. Relevancy.
Relevancy is Mr. McCreary is driving. He has no license.
Okay, are you just trying to tattletale on him for everything he does all day?
He's breaking laws, but I'm being accused. I'm innocent.
Okay.
I'm innocent.
It's still not relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy has executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they were convicted,
what does the officer have to do anything right now?
Well, this is the witness.
He's not an officer.
He's a witness, though. It's just
it's not the same. This was a very specific case. We have specific testimony. I don't care if he has a license or not. So sustained.
Well, what I'm saying is,
I don't care if he has a license or not.
Well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is I'm trying to establish.
You're not being accused. You have it.
Okay, I'm being accused. I have been accused. Yes, and there's no evidence. Mr. McCreary, can I ask you a question? Did you know that there is no evidence in this case?
Objection.
Why?
How would he? He's not an officer.
Well, I'm just saying there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not evidence under Opera versus United States.
Under the mission rules of evidence, testimony is evidence. Next question. Okay,
may I object under Opera versus United States? Testimony without cooperative evidence is not evidence.
Yes,
Jackson
so
versus Virginia.
That is incorrect. Next question.
I just say I'm being lynched today by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I brought in because of judicial bias.
It's not accurate.
Other courts have
under the
Michigan
Michigan court rules of evidence, under the Michigan court rules, under the rules of evidence. So I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and proper in court.
All right, now may I respond to the rules of evidence statement that you made?
You can ask the next question that's relevant to the exam you're saying.
Well, I mean, I can't ask everything. You shoot down everything I'm bringing, Judge. And I
object. If you don't have any more questions on cross, then you can say no more questions. You have a seat. If you don't have anything that's relevant to the direct test, the direct evidence that was provided, or the testimony on direct.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights, and I object to this whole proceeding because I'm denied to present evidence to call witnesses on my behalf.
No, you haven't been denied.
To properly cross-examine the witness, and then they're charged me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to women. It's that wrong. This is what I'm trying to understand.
You weren't charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay. What's the first part?
Assault with intent to great bodily harm.
Okay, assault with intent to great bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him. Where's the medical report?
So get to that in the argument. You'll learn elements.
I mean, I just object and I rest and I'll leave it to the circuit court as well.
You can't rest. You haven't even had an opportunity.
Well, I'm just saying because.
Do you have any more questions of the witness?
I mean, I'm being denied my rights to properly cross-examine.
No, you have any more questions of the witness?
Oh, no, because I'm denied the right to properly cross-examine.
Any redirect?
No redirect. No redirect, Your Honor.
Okay.
People have no further witnesses.
Mr. McCreary, do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and I also object to him not calling any other witnesses at this juncture because there's a witness list. And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses because they don't have a warrant judge. Like after we had the hearing when he attested in court, I just had 15 pages. This is all that we have. Where's the warrant judge? How am I charged? Where are magistrate's signature?
So as far as, this is the probable cause here. This is not, let me finish. This is not trial, okay? So the people do not have to present anything but what is necessary to show probable cause, not beyond a reasonable doubt. So if they want to call one witness, they can. You want to call the officer in charge on the case?
Well, can I call all the policemen that are on the list? Since he's not calling them?
You need to offer of proof.
Pardon?
Offer of proof as to why you need to call them.
Well, because their investigation. This is what I want to question them as to their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint, warrant, and a request for a warrant, and there's not anything here. How was I even charged, Judge? And there's no warrant.
So,
and of the 15 pages, I looked, and that's a violation of the 4th Amendment to the U.S. Constitution, Judge.
Great. You said you wanted to call the officer in charge?
Yes, the officer in charge.
Okay.
And the other officers.
Now, I will allow for the officer in charge because he's here, correct, Mr. Walkie?
Correct.
Okay. For the rest of them, you did not subpoena or bring anyone today.
Well, I didn't know he was not going to put them on here.
It's not his job to call your witnesses.
No, what I'm saying is they're on his list as witnesses, and I would like to basically get the court to have
he did not provide a witness list for an exam. In discovery and investigation report, I believe, is that what you're referring to?
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay, so you have a right to interview them and subpoena them to come to court.
Well,
and you ask the people to make them available to interview also before.
Yeah, I understand.
Okay, today we're here.
Well, in the 6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due process.
I will allow you to call any witnesses that you have subpoenaed that are here today, as well as the people's witness who is officer in charge on this case with officer.
Man,
call that.
Oh, yes. But man, I object to the court's denial of my 6th Amendment right to call witnesses and also in the MCR 6.110, because to establish a proper investigation, this court to be full aware of what is going on with this case and evidence concerning this case. I mean, these officers have to be brought forward so that we can ask them how they did the investigation.
And I believe that is a matter that you may, if you get bound over, can address at trial. There were several motions. It's the proper cause here, Mr. McCreary. It's very minimal.
Well, I mean, the rules are clear, and under due process,
they don't seem to be clear because you're still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut off.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person to stand?
I definitely will.
Step up to the court reporter, give her your name and spelling.
LOW.
You swear to tell the truth, no truth, and nothing but the truth.
Yeah, sure.
And you sit down, just make sure you speak up in the mic. Whenever you're ready, Mr. McCreary.
Can you give me like this, sir? Pardon? I'm here. Can you give me your name and badge number for the record, sir?
Officer Edward Pulowski, -4753.
You say Pulowski. Okay, yes. So you're the officer in charge, detective? Yes. Okay. On the day in question, what time did Norman McCreary come into your station to make the report? If I'm
I don't know the exact time he said he been ready to answer.
Right after this, then, so you didn't take the initiative to write down what time you came in here? You came into your office?
Your Honor, I'm gonna check the foundation. It hasn't been established that this witness actually took the report from the witness.
Okay, so where's that?
Let's clarify that.
Okay, I would like.
Lay a little bit of foundation as to
Well,
what his involvement is.
He's the head officer. Okay.
Lay a little foundation, which means ask questions about his involvement to get to the fact that you're questioning whether he knew what time.
I understand.
Right.
Okay, did you, are you the only one that had contact with Mr. McCreary?
No.
Okay, may you tell me whom Mr. McCreary started having contact with, in the beginning?
The officer Clannon who was working the desk.
Officer Clannon. Clannon?
Clannon.
Oh, Clannon, okay.
Clannon.
Clannon, okay. So you took the report, or Officer Clannon took?
Officer Clannon took the report.
Okay, and this is the report that's in this file that I may, this report here, sir?
You wanna?
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Or a written statement?
Yes.
Well, it says in the interview, like, questions are asked, and then the officer is writing the questions, then he's writing the
I'm
answers.
gonna check because it hasn't been established that this witness has taken that.
Well, he's the chief officer in charge of this case, so everything falls on him, just like you're supporting of Kim work, sir.
No.
Everything you do falls on her.
What are you trying to establish?
Well, I'm trying to establish time, place, and things of that nature. I mean, there is allegations.
Let's stick to the very specific question you're trying to establish with this statement, what?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak? Okay. Who did he speak with? What time reports were made? You know, to clarify everything in this normal query statement. Okay. So I'm trying to lay a foundation as to this investigation.
Okay, and that's not the document that the witness has prepared or is familiar with, because if he didn't prepare that, then you can't present that to him to tell him to refresh his memory or recollection about
Well, no, I was just asking what time did Norman come in to make a report.
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I have. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this?
Just
I mean,
but
5, it says end time.
Don't read to me on.
Oh, it says start time is 5.
Mr. McCreary, when I read to me what's in the document, do you have it?
I have a police report, yes.
Okay.
I believe he still has a statement. If it's written pen, it's a statement. The report is all typed.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
You have your report or your investigator's report?
It's all in the jacket. There's an investigator report, there's the police reports, there's everything, the warrant.
I don't have a warrant. Where? It's not in here, Judge. He said he gave me 15 pages and he attested this is all he had of last proceeding. There's no warrant here. There's no authorization from the prosecutor here. And then if he pulls anything else out, that's a Brady violation.
And you may have it. What is shown?
It's not here.
You don't even know what he's about to show you.
What I have that was in the packet, discovery packet, is the Troy Police request for a warrant, investigator's report. It starts on page 3 and appears to go through page 6.
National report you just had.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay,
legible.
let's stick to, do you want to
Yes.
present that report to refresh his recollection about the time?
Well, no, I was asking him.
But that was the line of questioning.
No, that was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCreary, my brother, came into the police department and made a report.
Yeah.
This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after, This is you testifying, first of all. There's been no testimony that anyone came out on text.
Okay, well, look, I'm just saying he's objecting to everything, and I have foundation and right to ask these questions.
Just ask about that.
Okay. Okay, so you stated that you're the chief officer in charge of this case, am I correct?
I'm the officer in charge, yes.
So you just stated under oath that you didn't know what time that Mr. McCreary came to the police precinct to make a complaint.
Not the exact time, no, sir.
Okay. Here, I would like to teach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
I don't remember what date I sent it exactly, but yes, we sent the entire packet over to that prosecutor's office.
Okay. At your what's the word I'm gonna use? At your direction, did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you. Once we do any kind of felony case, I gave them to our special operations unit who works out the 10th precinct. I know that there's probable cause to arrest somebody. If they come across somebody, they'll lock them up on that case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
There should be, because you're reporting.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation. It's blank. It's blank. Now, my paperwork's supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witnesses unless there's a special.
You're talking about the warrant, sir, not the protection.
I'm explaining why the difference.
I'm not a threat to him.
So.
It's the last page of investigator's report. That's not going to be an actual warrant. That's set in with every investigator's report.
Well,
the authorized warrant is going to be the black and white with all the charges.
Okay, can I actually a warrant where?
So there is an information.
The objection that's not signed, notarized, or approved by court. The court rule.
That would be a motion that you can address if this gets found out regarding the warrant.
Right. Well, I would like to continue my cross-examination if I may, Judge.
Please.
How long have you been an officer? Officer Pulowski, you said it is?
Yes. In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Right.
May I ask where?
City of Westland.
City of Westland. And you say you've been in Detroit how long now?
7 years.
Are you familiar with the strictures of the Fourth Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't an attorney.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law enforcement?
No, you don't.
Yeah, I know about the Fourth Amendment, yes.
Okay. Again, was there a warrant when you arrested me?
I did not arrest you.
Well, your officers. You should know what your officers are doing. Notice the agents, notice the principal.
Question. What's the question?
Okay. Did your officers have a warrant when they arrested you?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime. I would like to state this. In 2001, the Department of Justice indicted DPD for drag net arrest.
Okay.
And this violates
So I'm
the
denying that request. You can be arrested without a warrant.
Can you show me the law where that is?
No, it's not my job to show you that.
Okay, well, I'm saying under federal case law and state case law under Article 111 of the Michigan Constitution of 1963, as well as U.S. Constitutional Amendment 4, enforced upon the states, they have to have a warrant, Judge.
32 hours.
72 hours.
Charged.
Well,
at some point, I don't know, but that's once again outside of the purview of this exam today.
They are committing felonies, Judge. This is the
and I am not the police department. I'm not the FBI. I'm not the Department of Justice.
Okay.
The charges here today are assault with intent to murder, assault with intent to do great bodily harm, less than murder, or by strangulation, weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon, assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay.
Okay, so you guys just heard all of the charges that this man is facing. These are some very serious charges, and one would think that with such serious charges, they would hire an attorney to represent them. This man is making a complete fool of himself in court, as if he is it's like he's not taking this case seriously. Lawyer up, buddy, because if you don't, you are going to get found guilty of all of these charges, and I'm sure you will be sentenced very heavily.
Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law, so far as the desk officer, or you give the interview? Are these articles available?
There is no body cam footage used on the front desk. It was all recorded at the station.
Okay, within the station, why haven't you put that evidence into the discovery so that the people can have it?
If that is requested from inside the station, it can be put in there, yes.
Okay. I'm looking for this page. Okay. May I take you to, I believe it's page 6, Detroit Police request for warrant. Before you was off, please, sir.
I don't take anything. I'm not supposed to take anything.
You don't have anything. Okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? Okay.
Last page. No.
I would like that back, but I would like to ask him a question when it concerns that.
So you want it back, or do you want him?
No, I want him to look at it, and I want to question him about it. But once he's done with, I'm going to be questioning him. I would like that paper back. That's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence?
You established what it is.
Oh, okay. That's the can you read that for the record, sir, at the top of the page?
Well, actually, you will have to ask some questions.
Oh, okay. Can I see yours, Mr. Prosecutor? Because yes,
yeah, sure.
Okay, you have in your hand what's called a Detroit Police request for a warrant. Am I correct?
Right.
Okay, on the top part it says admissions and confessions. What does it say?
None.
Okay, lineups. What does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence.
None.
Okay, and then you have the witnesses. Then it says video. Can you tell me what that says, sir?
Body worn camera footage not available due to the report being taken at the desk.
Okay, and photo.
None.
Okay. So is this typically how the 10th precinct operates? No warrants, no evidence, they prosecute individual citizens. Is this how this happens, sir?
So when I submit one of these?
That's a question, sir. I'm asking the question.
Yes, this is typically what ours looks like when we send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants. I'm saying, is this a policy or a custom with your department, 10th precinct, sir?
What policy just?
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
Every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, sir?
Of sending it down warrants? Yes, I have a history of sending
without evidence and without arresting people without warrants. This is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm going to object because
let him finish the objection.
The witness has already testified that he did not arrest him.
Or have a warrant at the time.
Well, what I was, Judge, what I'm trying to establish.
You're trying to establish way more than was needed for this exam. This is a whole holistic type of approach you're trying to have here with the police department, him worthy, the bench. I understand that, but As far as this case, if you're not getting to specifics about what he did, he's not even seem to be that involved into what.
Well, what I'm saying is that right now you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. They move at his direction. If they don't move at his direction, that means they're vigilantes, Judge. They're just doing what they want to do.
In your opinion.
I mean,
so what is your next question?
Well, my question is, does he have a history of arresting and charging innocent citizens without warrants and without evidence? And I know I have.
Answer?
No.
Next
okay,
question.
I would like, now to establish that he's telling the truth, I would like to file a motion for the discovery under MCR 6.201, which allows this to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this has already been proved in other court proceedings. And I would like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to many other individuals. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the law of the 14th Amendment. Judge.
I'm denying that request. I know you'd like to object. Please object to the record so we can move on.
Judge, I mean, now, like I already placed my objection, I'm being denied my rights to a fair trial.
Okay. It's not a trial. That's
not my trial. Well, this is a hearing. Exactly. But I'm still entitled to my rights in a hearing.
It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different things. With all respect to the court.
Now, this man is facing charges of attempted murder, and his line of defense is trying to question the officer as to whether they had probable cause to arrest him. How is that supposed to help your case? You are not going head to head with the officer. You are going head to head with your brother. The officer was just there responding to the incident. So you thinking that you're going to win this case by proving that the officers falsely arrested you? You are out of your freaking mind. This literally makes 0 sense.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam or whether it's statutory.
All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of did you receive some form of legal training when it concerns your job? You went to the academy back in the day.
Yes.
Okay. Did you know under MCL 750.505 misconduct offense that is a 5-year felony that you have committed against me, sir, based on lack of evidence, no warrant, sir?
I'm going to object.
Well, the objection is not founded, prosecutor.
Let him have his words, but I don't know his objection is.
Relevancy, defendants testifying, he's accusing of crimes.
Argumentative.
Argumentative.
I
know. So the question just doesn't make sense.
Can I respond, please? Sure. I mean, it goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the mayor.
You're not about to convince me anything. Yes, mentioning Kwame Kilpatrick's conviction. So.
All right. Well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions.
Well, it's not relevant.
Well, it's relevant because he's committed a felony.
That's an accusation. It has not been presented to the court in any matter other than you telling him that he committed.
Well, can I again ask this court on the MCR 6.201 Brady versus Maryland request his background history for purposes of impeachment at People versus Stanaway, which allows.
More discovery?
Yes, I would like to have more discovery so far as impeaching his witness because.
So, Mr. McCreary, if this is bound over, I will sign the discovery order.
Well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly
Discovery is
cross-examine
an
the
ongoing, it's ongoing.
Well-
So today, the exam, if we're in the middle of it, we have plenty of time to prepare for this day. If it gets bound over, I will sign a discovery order, and you can request.
Well,
Okay.
yes, ma'am. Under People versus Date, again, I say that citation I will have today here in court where Judge Rosen dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
That's an argument that you can discuss this during the argument once you're out.
So he's not allowed to answer the question that I asked him so far. So,
No, I'm just saying.
okay. Are you familiar with Mr. McCreary or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact.
Okay. Are you familiar with the Sergeant Wall that worked at your organization?
Yes.
Okay.
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there, the sergeants at some point. I just want to make sure I have the right one.
Yes.
Okay.
Okay, so you did your investigation. How did you come about knowledge of McCreary beside with his brother? How did you know how Mr. McCreary looked? What information did you find out where he lived? Did you do a mean check? Did you check the system for pictures or addresses? Did you do any of that, sir?
So typically when I get a case, it pops up. We call it our hopper. It's where it lists all of our cases we got for the day. I make my initial calls, try to make contact with victims, get them in for another written statement because sometimes we get a police run. People's minds are elsewhere, or they don't ask the right question. I might need more for my investigation. So I get them to come in, either me or someone else who might be you. Get a written statement from them so I get more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor?
A warrant prosecutor?
Yes. Typically, I remember from back in the day, you know, like they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's part of the jail.
And also, I'm gonna check the notes here.
Other than you establishing your argument that there was no warrant signed, what is your?
I'm trying to show how his investigation came forward. I know I've read things concerning the Fourth Amendment. Fruits gathered after an illegal search and seizure are intervention in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like this. The prosecutor didn't even sign off on this.
Okay.
And I'm just trying to.
I'm sustaining the objection. It's not relevant right now. You can put that in a motion if it gets bound over.
Are you aware that Mr. McCreary, past and present, has come into your precinct, made complaints against your officer there?
Your brother, Norman?
No, me, Cornell Michael McCreary, ill.
I'm gonna check.
Oh, it's relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything
relevant.
you're saying is for impeachment.
People versus Stanaway. Stanaway laws.
It does not say you can impeach on anything. I know that case law does not say that. You can say anything if it's impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP. Okay. Because of numerous complaints against them, because of recording them, putting them on YouTube, where they told an officer to break in the house.
On the stand, doesn't know your brother, McCreary, until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind with you too, y'all. This gentleman here. Okay. Did you ever look at Mr. McCreary's picture? It was stated in here that you showed, or one of your officers showed Mr. McCreary, my brother Norman McCreary, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in the discovery.
It's included in my packet. It's over the APA's office. It's the Michigan SOS picture provided to me by the law enforcement information that we call lien.
And what came up in the lien? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor, it's your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot me down. I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated in here, so I'm going to show my driver's license. Okay. Did you ever look at Mr. McCreary? And I object to the denial of that. Did you ever look at Mr. McCreary's driver's license?
His actual license? No.
Which Mr. McCreary?
Me. I'm talking about me when I addressed me. Well, Cornell McCreary. Did you ever look at Cornell McCreary's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system.
It wouldn't be your license, it would be the picture provided by lien.
The picture by lien. Oh, okay. Lien system. I didn't okay, so I believe on the paperwork it says a CTN. What is that, a CTN, sir?
CTN?
A CTN, like on judgments, warrants, things of that nature. It says CTN, then it has ORI.
You asking me what a CTN is?
Yes.
So that's going to be generated by the system.
No, I'm saying you give me a breakdown and define what CTN.
It's not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, could you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay. So you don't know what a CTN. Did you know that a CTN is?
I don't know objective relevancy.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning.
Well, I can't imagine what a CTN has to do with.
Well, it's a cargo tracking note.
I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. It's placed on the record. This is objection to my CTN. He's saying that objection.
So you stated that you looked at my ID and whatever else in the link says. Right. Okay. Did you know that me, Colonel Michael McCreary, reserved his rights not to be governed or controlled by city, county, state, federal officials? Well, I mean, it's relevant. I tried to establish relevancy.
It's relevant to you, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong judge. I'm not doing business with the corporation. This is what I've been trying to establish, but you're limiting my defense. My defense.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help
you. What did I say?
And I have those rights.
What did I say?
You said after the fact, it was bound over, you will sign a discovery order, but I'm entitled to that to do a proper defense.
That's what I said. That's not gonna change.
Well, under federal law, I have a right to present a defense, and this court is denying it.
No, I did not deny you at all. We've been here for over an hour. You've been presenting things to us.
Okay, I mean, I can't question this guy because this officer, because the court and the prosecutor keeps objecting. I'm being denied the right.
Well, maybe because you're not that great at.
I mean, I'm very well. I mean, I have a right to.
You're not that well versed with the court rules or evidence.
Well, I fight with constitutional law, which you have ignored, which you have.
Definitely fight with it.
Well, I'm just saying under the Constitution, this court is bound by that.
I know what I'm bound by. Do you have any other questions?
I mean, I'm being denied, so I would just object, and then I would once if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paperwork. And you know, like I said, I'm in the process. I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
You have any more questions of the witness?
I mean, I can't question them.
Yes or no?
No, I can't because I'm being denied.
Okay. Any cross?
No, Your Honor.
Okay.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you denied it.
Thank you.
I said you did not subpoena them or ask the prosecutor to make them available for you to interview them for the exam today. So they're not here. So you're not prepared to call them.
Well, I just want to say this for the record. So just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in the Supreme Court, that you would be removed and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence. I mean,
The higher court, that's why I'm at the district court level, so that's what higher courts are for. So they can address.
But it's okay, but may I respond to say something? Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
Mr. McCreary, I don't want to hear about it unless it's about your argument in response to people resting after they rest. Well, actually, they rested already. And you don't have any other witnesses present.
Well, I mean, I'm denying my witnesses.
You never denied. You were never denied. You had a witness list, you didn't contact, you didn't ask the prosecutors to provide them.
I didn't think
or make them available for you to interview, or contact them or subpoena them to come to them. This has been adjourned several times. You have plenty of time to do so. I've let you go to the library to research. I've let you even go to the court to file a lien against my house.
No, I'm waiting.
I've done way more than I should have allowed you to do. So I am not going to adjourn this or provide a discovery request to you or grant that based off of you not being prepared today to call witnesses that were provided to you on the witness list. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I
Yes,
may. Because you say I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Jurov. I have many other people that are willing to come into court and testify. And I'm being denied that. I would like to just again to clarify for the record that I didn't think that you would be moving forward because I was just in a court proceeding with Judge, what's her name? Where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then they have to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accused me of being biased, so why would I make a decision?
I mean, but what I'm saying is you.
Why would I make a decision on something where you're saying that I'm biased to you?
Well, I'm about to answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it, okay, it would have been sent for a blind draw. Per the rules and under people versus
this is blind draw. This is not trial. This is the exam stage.
I understand.
Okay? So you don't have any further witnesses. Today was the exam.
I mean, I wanted them at the exam.
They're just not here because you didn't subpoena them, ask them to come, or ask the prosecutor to make them available. So I'll be in.
Thank you, Your Honor. Your Honor, people move, bind over the defendant on all charges. It's a matter of it's a question of fact. We have one witness that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon, and therefore he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle. And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and find this over. And you know, he took aim at his own brother and shot at him. So we asked for a bind over on all charges.
First and foremost, I would like to object because by the officer on admission and the prosecutor knows fully well, there's no evidence, Judge. Not just that, the witness lied here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he committed perjury right here on the stand. Also, the burden is on the prosecutor. I'm innocent until proven guilty per administration of justice. Again, I adamantly object and deny these allegations. He's stating that ammunition, all that, where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother, who has lied in the past, and he has a dishonest history, and he has a history of theft. And let me finish. I didn't object to. I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
He's objecting.
That's fine. I didn't say that when he was talking.
We've been talking all day.
I'm gonna object because these are quoting facts that you try to get into evidence and they're not in it.
Mr. Salaki, I know the difference.
Okay.
Objection on the record. Mr. McCreary.
Okay. Under Opera versus United States, 348 U.S. 84, the Supreme Court held an accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and corroboration by independent evidence is required. A, the requirement of corroboration applies to exculpatory statements to the same extent that it applies to incriminatory statements. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this, like, to prove that the corroborative evidence need not be sufficiently independent of the statements to establish the corpus delicti. It is sufficient if the corroboration supports the essential facts admitted sufficiently to justify a jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this vindictive prosecution to proceed, Your Honor? They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth, who is in the community is known as a liar and a perjurer. And I wanted to call Chief Judge Burtney, who's in Wayne County 3rd Circuit Court, to establish this, that he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies. I mean, it's factual. So at this juncture,
all of that is the trial at the 3rd Circuit.
But again, I would like to object to this court's hearing of this exam for judicial bias, because under Kane versus MPLC, it says that even if I can show bias, justice teaches that the judge should recuse himself because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been arguing the law, and the court overruled federal law, which states.
Some of it's bad law.
Okay, well, I've researched it. I've researched it and I've shepherdized it, and it's still good law.
Okay. So, okay. Mr. McCreary, you have made your argument and objected for the record. And would you like to preserve that? Argument that there's no evidence presented today, what the court has to remind defense of is that testimony is evidence, whether you like it or not. I do believe that witness Mr. Norman McCreary was credible, and the burden of proof is on them, and they have to show at the probable cause standard. First, assault with intent to murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCreary, tried to by not only aiming but also firing a gun That's the complainant witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he didn't have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or produce the crime. That would be a question of fact to be tried in fact as to the intent and what Mr. McCreary was doing. Pointing the gun, and I do believe that the probable cause standard, pointing the gun and shooting someone shows intent to kill. As far as the remaining charges, assault with intent to rape by the harm less than murder is lesser included, satisfied by the evidence of testimony. The count 3, firearms possession by the felon, has been established in Exhibit 1, in which Mr. McCreary was not eligible to be in possession of a firearm, as well as count 4, ammunition in the weapon, satisfies count 4, ammunition possession by a felon, and count 5, assault with dangerous weapon on his assault, has been satisfied based on the same testimony from the complaining witness, and of course the 4 accompanying weapons, assault firearm charges. So, Mr. McCreary, you're going to be bound over to 3rd Circuit Court, Framework Hall of Justice, for your arraignment on information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from either party?
No, nothing from the people, Your Honor.
Mr. McCreary, other than your objections?
I would like to place my objections on the record because throughout this entire proceeding, I feel that this court has been biased when it comes to rulings. They've even allowed this prosecutor to use state law to supersede federal law, as stated in Cohen's versus Virginia, that is considered treason against the United States Constitution. These are landmark cases. And also, you know, the witness lied under oath by stating he didn't do this, this, and that. And I mean, under standard due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness. Well, I mean, you asked me that anything else to sound.
Anything else? Anything additional?
Well, I'll object. I mean, I'll just let you buy me over. And can I say one more thing? Again, like I challenged jurisdiction before testimony was even brought in.
And I denied it.
And, okay, but the law mandated.
Discovery order signed? Before I buy you over?
Yeah.
Okay, what was it specifically that you?
I mean, I would like all the officers, background history, Kim Worthy's. I would like the individuals here today because it shows a pattern in history of felonies being committed against citizens.
So what I'll do is I'll sign this discovery right here, and if you want to expand it, with the new judge that you get across the 3rd Circuit, you can ask for those additional things like Kim Worthy's background. I'm not giving you that. I don't even know what that is.
Well, what I'm saying is so far she's the chief officer of the county.
Yes.
And everything.
And I am not going to do that.
And everything that her subordinates do.
I'm signing a normal.
Well, what about the bond?
Scale certified discovery order for you to make sure that you have everything in any video. It was mentioned that there was video possibly at the police station. This will get you that into the goods. Okay.
Okay, well, what about the bond? I mean, I didn't run, I'm not a runner. Why do you got this tether on me? I mean, I can't get out and work like I need to. I can't get out and move. I mean, I don't know what my brothers say. I'm not trying to do anything. This is a complete fabrication.
I give you a lot of leeway.
Pardon?
I give you a lot of leeway. I'm going to continue by.
I have a right to live. And my liberty is being restrained by these people who are committing felonies.
And the other option is within the Wayne County Jail with assault and attempted murder charges. 6:29 at 9 o'clock. Okay.
Oh,